Hi, everybody. I know we're going to start in like 1 minute. Um, Mark Wegg's having a little difficulty with the video, so you'll just see his name on the screen. Uh, on the one of the panelists with us is Andrew Finkelstein. He's an attorney that I sit on the board of Empire State Bank with. He's the chairman, and I'm the vice chairman, and we also share office space here in Staten Island. He is the managing partner of Jacoby and Myers and also Finkelstein and Partners. Many of you know Jacoby and Myers' name from the New York City area. Um, so we're here today to educate our clients, especially the clients of ours that are in a lot of trouble financially because they've been forced to be closed down. Many of you have already applied for this SBA PPP loan and also the EIDL loan. And I think a lot of people thought the EIDL loan would be the saving grace, but as many of you know, that loan capped out at 150,000. It was originally a $2 million loan amount. We are seeing some clients getting those loans now, but as many of you know, that's not really going to make much of a difference. I mean, it will definitely help. So in speaking with Andrew over the last couple of weeks, because we've been speaking on a daily basis trying to help clients with the SBA loans, he informed me that he felt, and he will go into more detail on this, that whoever has business interruption insurance, he knows that many of the insurance brokers and insurance carriers are going to tell you that there is an exclusion in the policy for pandemics. And he believes that many people should apply and make a claim under this provision in the policy, and most likely you will get denied. And when you get denied, you can fight that by hiring an attorney. So I'm going to let Andrew, and I'm going to let Andrew speak on this now. And if you have any questions, you can type them in, and then Mark Webb will intervene and ask Andrew the questions that you may have. So Andrew, thank you for speaking today, and if you'd like to just give us a background on the business interruption claim process, that'd be great. Thank you.
Sure. So welcome, everybody. Thanks for the opportunity, Walter. What I think I'll do is I'll talk for 20, 30 minutes. And then as I'm talking, you'll see on the bottom of your screen, there's a chat button. And I'm happy to answer questions. This is a real broad area. And frankly, I can't get into too much detail. So I just want to provide a overview and a broad structure as to really what's going on in this whole area of the law. Just by way of background, Walter shared, my name's Andrew Finkelstein. I'm the managing partner of 4 different law firms. All of them represent individuals or businesses against insurance companies. So I've made my career fighting carriers, and the carriers are the ones behind and promoting tort reform. And I put it up as a sign, tort reform. Well, the easiest way to get rid of all of our lawyers that do what I do is all insurance companies have to do is honor the promises that they make and be fair. If they were fair, I'd be out of business. So I just want to share that I've gone after many, many major insurance companies. I go toe to toe with them. And what I'm involved with in the business interruption side is there's an organization of lawyers nationwide where we meet and we discuss what's happening and we communicate amongst ourselves. And we know this. We know that insurance companies have organized and agreed as a group to deny every one of these claims. They have, and it's the first time anybody, certainly I've seen it, or anybody that I know has seen, where not only have they decided to deny every one of these claims, they have proactively tried to prevent claims from coming in. They have already communicated, and I've seen a bunch of form letters that they've sent out to their policyholders that tell, out of the box, in substance, they say, "Dear policyholder, don't even bother filing a claim because you have no coverage. We've excluded this coverage." Well, that is far from a secure position. And all they're trying to do, and if you think about if they, I'm going to make up these numbers, but if you think about one insurance company, if they evaluated all of their business interruption policies and think they have $1 billion of exposure, and they've calculated that, well, if we preempt any claim coming in by sending these letters out, that we're going to knock out 50% of the potential claims, they've just saved $500 million. And then they'll fight on the 50% of the claims that come in, and it's a war of attrition. And what they try to do is wear people down and say, it's just not worth it. I'll give up. And then for each one of those, they're just making more money is really what it comes down to. And then at the end of the day, those who are left standing, if there's a meritorious claim, they pay. So my approach always is to frankly fight and go after them, because my experience is they understand that the amount of fall off that they've created makes this potential issue really a non-issue. And they've already done it two specific ways. They've gone out into the press, into the Wall Street Journal, on the business channels, and they've said, if we have to cover all of the claims that for this business interruption for pandemic, we'd be out of business. Well, they've inflated those numbers. The way they've inflated those numbers is they've taken the entire economy, assumed nobody goes back to business, generates any revenue, and then they suddenly have to pay for all of it. Well, that's just not what reality is. Reality is they are limited by the amount of insurance that they've written policies for, and not everything is covered. So they've completely inflated their exposure, which they know they don't have, just to put the fear of people out there to not make claims. So that's step number one, is have a proactive publicity campaign. And then step number two is affirmatively tell all of their representatives to send letters, or when anybody, and I'm sure there are people on this webinar who have called your agent and said, am I covered by business interruption? The immediate response is, no, you're not covered. You got no shot. Don't even bother making a claim. That's a system-wide intentional response. So I want to talk to you why it may or may not be covered. Just because, let me half a step back. Business interruption policies. It's important to understand what is an insurance policy. And it's very simple. It's a contract, right? As a policy holder, you pay a premium, and in return, and that's it's a quid pro quo, you pay a premium, and in return, they are supposed to provide coverage. And there's two, if coverage for the type of event that you've purchased insurance for. And really what they are saying is you didn't purchase insurance for this event. Well, basic contract law provides for this. First of all, insurance, there's two types of insurances. There's what's called a specified peril insurance, which is you are insuring a specific event or covering something. And you hear like Lloyd's of London will insure Joe Montana's arm or something like that. That's a specific peril. That's rare. You may have that. But most insurances are what are called all risk. They cover everything. So when you purchase insurance that covers everything, there's always a presumption in law there is insurance, unless the insurance company provides an exception. Okay, so what they have to do is they're called exclusions in the policy. So the presumption is everything is included unless it's excluded. So the exclusions are where all the fights are. Because in order for an insurance company to exclude coverage, they have an obligation. They're the ones who write the policy. And when they write the policy, it's called a contract of adhesion. There's really no bargaining when, if you're a business owner and you say, I want um, business liability coverage and uh, all coverage related for my business. And you say to the broker, make sure I'm covered for everything. And then they provide all of these exclusions. And let me just, so we use the legal language, provide coverage for everything. That's called an endorsement. They provide an endorsement and cover business interruption. So that's what the endorsement is. You have business interruption insurance. You have it. You got to look at your policy. You have it until they exclude certain aspects of it, or they define when you are allowed to have it. So the fights that happen in court are over the language of that exclusion and the language of the endorsement. First, do you have insurance? And then second, what part of it was excluded? Very big picture. The insurance company has to be exquisitely specific when they are excluding coverage for a specific reason. If there's any inconsistency in the language, it is interpreted against them, because the presumption is there is coverage. The presumption isn't there is no coverage. The presumption when a court looks at an insurance policy is, okay, there is business interruption insurance. Did they properly exclude it? And again, if there's inconsistencies in that language, it'll be interpreted against the insurance company, and the presumption is that there is coverage. Now, there are about 6,000 different insurance companies, and multiples of that on their language of their policies. This is not a cookie cutter scenario where business interruption policies are all the same and that all the exclusions are the same. So that's why I have to be very general when I'm talking about this. If you have specific questions about your specific policies, I'm not able to answer that at this time, but you should understand that even if there is business interruption exclusions, that doesn't mean you don't have coverage, because there are other areas of your policy that may provide for coverage, which is something called civil authority. A lot of coverages provide for if there is property damage to the property that prevent the occupants from going there, and there's a whole debate as to what is property damage. And this isn't the first time, it's certainly the first time there's been a pandemic. And that's what's most interesting. These policies, I haven't seen one yet that has pandemic exclusion. So what they're trying to do, and when they wrote these policies not considering a pandemic. There are some policies with pandemic exclusions. I just haven't seen one yet. So they are taking language that they wrote for virus or bacterial exclusions and trying to suggest that that applies to a pandemic civil authority. Well, from my position, they're trying to put a square peg in a round hole. If they wanted pandemic exclusion, because remember, just going back to the beginning, the presumption is there is insurance. So the presumption is there is insurance for a pandemic issue. And the arguments that have been made and will continue to be made, and there are no decisions yet, is does a virus or bacterial exclusion include a pandemic civil authority response? Nobody has the answer to that. So what I was talking to Walter about, and what I encouraged I'm encouraging everybody to do is to file a claim. So remember, insurance is a contract. So as a policyholder, you have certain obligations. One of the obligations is to notify the insurance company that you are making a claim. So you file a claim. There's no cost for filing a claim. It's a simple letter. In fact, what I'll do is after this, I'm sorry I didn't do it ahead of time, but I'll give Walter some standard language that you may want, but the broader, the better, that substance would be that I am a policy holder. I paid my premiums. I am making a claim for all benefits under the policy as relates to the government shutdown as well as the pandemic issues that have prevented my business from operating. Very broad, okay? The broader, the better. But you want to cover those two broad areas, which is the pandemic issue and civil authority that the government has stepped in, because those are the two broad areas that you'd likely have coverage. And make a claim, guaranteed 100%. You will then get a denial. If you have already received, without making a claim, a letter saying you have no coverage, that is not a denial, and you are not in a position to really bring a legal action yet. In order to have a legal action it's a contract, and you are acting in consistent with your obligations under the contract by making a claim. And once they deny that claim, that's what triggers the potential legal action. Doesn't mean you're running to court right away, but it becomes ripe where you have the ability to, if you so choose. So once that denial comes in, then it's an examination of did they issue a proper denial, right? Because they have to deny the claim consistent with what their policy is. So if they're not consistent with, if they have an improper denial and there was insurance coverage, there's timing components to denials, and it's not likely they'll have an improper denial, but that's just one avenue. Assuming there is a proper denial, then it's really a fight over the language of that insurance policy, and that is decided by a judge. Is there coverage or isn't there coverage? And there are, as I said, 6,000 different insurance companies, all with different language in their policies. And sometimes their own policies are inconsistent in one area of the policy, which is what they would communicate to you in their denial letter that says, oh, there's a virus and a bacterial exclusion, so you have no coverage. They then don't also tell you in a different section of the policy where you may in fact have coverage under the civil authority section. So what they're doing is, the way I started this, is they're hoping you'll just go away with that basic denial. If there's an inconsistency in the insurance policy, in one area there's a no coverage, but in another area there is coverage, right? So you may be able to get to the benefits of business interruption through the civil authority versus through the I'll just call it the pandemic, the bacteria, if you have a virus or bacterial exclusion. Not all policies have virus exclusions, bacterial exclusions. When the policy does not have an exclusion, there is insurance, right? Again, the presumption is insurance. So it's really, it's just reading the policy, and with all due respect to everybody on here, I don't know anybody specific, but unless you're an attorney who practices in this area, you may read things that fall, that you just miss. So the simple conjunctive of or versus and. With property damage cases, Oftentimes whether there's coverage, it could rise or fall, whether the property damage requires and versus or. I'm just giving you some illustrations as to why it's important to have somebody who's experienced in this to read through it, because to a layperson you would kind of miss that. So that's kind of really, I know that was kind of fast, but that's my broad overview. I can keep talking about the issue of physical damage to the property. You know, don't miss that physical damage need not be seen. Virus and bacteria constitutes physical damage. It's clear that you can have a chemical exposure in the area that constitutes physical damage. So physical loss of property is different than physical damage to the property. And when you read your policy, you'll probably see both, that the property must suffer a physical loss of property or physical damage to the property. Alternatively, if it says physical loss of property and physical damage of property, that creates a greater burden for you to determine that there is coverage. So I don't know if that's a broad enough overview for you, Walter, or you want me to keep going, or you want to take questions? Can't hear you.
We do have a couple questions you could take.
Okay.
One question we have is, will filing a claim result in a cancellation of my insurance policy?
The answer is no. And if they do, you file a complaint with New York State. It's the Department of Financial Services. Filing a claim is your right as a policyholder. They can't deny and cancel your coverage simply because you file what you believe is the benefits of a claim, the benefits of what you paid a premium for. So if they do, I would encourage you to file a complaint with the Department of Financial Services. They can't. Okay. Let me also just add that I'll just speak for me personally, and most lawyers who handle this type of work recognize that the financial challenges of people who are making business interruption claims are frankly financially strapped. So my firm does it on contingency, meaning you never write a check to my firm. We do it, we're side by side with you. If we win, we receive a percentage of the recovery. And depending on how far that litigation goes, to kind of determine it's a sliding scale, determines what that percentage is. But if we lose and the court says there's no insurance, then you owe nothing. You'll never write a check to my firm. Most lawyers who do this type of work, that's how they operate. Some don't take the risk and they're concerned, so they charge hourly, but you should certainly inquire about that.
Another question we have is this something that's just automatically included in the insurance policy, or that is an extra something that to sign up for?
So business interruption, it goes towards what type of coverage that you have generally, and I'm going to say very generally, it generally is included. If you pull out your policy, it'll say right on top, business interruption. It'll say right on top, civil authority coverage. So you generally have that. It's called an endorsement. You have that endorsement in your standard business liability coverage. And then first you have it, and then they try to take it away with these exclusions. So yes, generally you should have it, but you have to check. They're all governed by individual policy, so you have to check that individual policy.
I have a question from somebody now. Some people are saying that if your policy is about to expire, your current policy, that it's very important that you file the claim prior to this expiration date, because the new policy will probably have language that protects the insurance company. So maybe you could speak on that.
Yeah, the timing of the claim in relationship to the expiration of the policy, it's just an added fight, but it really doesn't, it's not determinative of whether or not there is coverage or not. It's really, your policy says when you need to put the insurance company on notice of the claim. So the policy doesn't have to be, I'll just call it in existence at the time that the claim comes in. It covers a period of time that the loss occurs. So if the loss is occurring now, I definitely encourage you and would recommend make the claim while the policy is in existence. But if you're right on the edge of that, you would still have coverage if the claim came in after the expiration of the policy. But you don't want to be in what's called a late notice situation where you did not put them on notice timely. So it's going on. You don't have to wait till all of your losses are in place. I would encourage people to make the claim now and get that ball rolling. And related to the end of a policy period, the end of the policy period doesn't mean the end of the insurance company's exposure to pay you. So let's just say hypothetically your business interruption started May 15th and runs through July 1st, but your policy ended on June 1st. That policy from May 15th pays through July. It doesn't end when the policy period ends. That's when the harm has to occur, but the policy period extends over.
Okay, we have
Another,
another question. How do you generally figure out how much somebody can claim? Is it based on a loss of
All
revenue?
right, so that's a very good question. So it all depends on what it's called the endorsements are in the policy. So there are a lot of policies that provide for a lot of benefits that you likely don't even know about. So there's you could have reputation risk. Just hypothetically, if you're a restaurant and there was some exposure of COVID in your restaurant, you may have a provision in your policy, you wouldn't even know about it, that has reputation risk. Well, they'll provide X amount of dollars for you to go out and repair your reputation. There's refurbishing coverage. There's all different lines of endorsements and benefits in your policy that you may have that you're not even aware of. So how do you figure it out is by reading the policy. The easy one to think about is the business interruption is if the policy usually has an endorsement for lost earnings and lost revenue. And then they'll talk about what they can offset as against that. What they cannot offset against that is the PPP loan or any other governmental benefit. It's called a collateral source. That is not a collateral source for purposes of insurance. But what you always have a duty to do is mitigate your damages. What does mitigate damages mean? If you have an ability to generate revenue, even though it's not the same level of revenue that you had before, if you have the ability to, and you can, you must. Otherwise, they get a credit for that. So I'm just going to make up a restaurant that has not all restaurants have the ability to do delivery or curbside pickup. But assuming that you are, and if you choose not to, because the cost would outweigh the revenue that you would generate, the insurance company technically could take a credit for that. So if hypothetically you were your revenue was $1,000 a week, and you determined that you would only generate $100 a week for curbside pickup, and you choose not to do that, you choose not to mitigate those damages, really your claim, and this is what the fight is always about, the claim would be for $900, not the $1,000. But who has the burden of showing that you didn't mitigate? That's the insurance company. So you start with your claim being $1,000 in revenue, and that's really kind of where the battle lines are drawn. But that is a good argument to be in, because that argument only happens after there's a confirmation that there in fact is insurance coverage. And before I take another question, I'll just very broadly, there's all different litigations that are going on. Okay, I'm aware of about 175 right now across the country. They're in state courts, federal courts, there are individual actions, and there are class actions. So there's just a lot. Whether or not there actually is coverage really won't be decided for a minimum, and I think this is early, 9 months to a couple years, because I suspect that an insurance company, whatever that decision will be, if they lose, they'll likely look to appeal it. But it won't cost you anything. But if you don't file your claim now, and it's determined in a year and a half, there in fact is coverage, then you have to make the claim. You won't be able to make the claim in a year and a half.
You I think answered this. There is another question though. You alluded to it. So they can't offset your claim with a PPP loan or any other government credits or loans?
Yeah, it's called a collateral source, and that is not a collateral source. The answer is no. I mean, there's no law that says they can. Does that mean they won't try? Of course they'll try, but there's no law that says they are allowed to, and it's not in the contract. So they can't.
Okay, I got one more question here, regarding franchises. So since franchises often have the same insurance company and policies, person asking the question has a franchise. They've already received a negative response from the carrier.
Of course.
Would it make sense to coordinate and work together with the other franchise counter responses?
Sure. But, the reason why I say it would be smart to coordinate with other franchises is, I'll give you an example. If I had, I'll make up a number, 100 franchises, and there's some in New York, New Jersey, Connecticut, and Pennsylvania, what we would do is pick the best court with the best likelihood of interpreting that section, because this isn't the first insurance claim. There's Hurricane Sandy. There's lots of prior insurance claims. There just isn't under the pandemic world, but there's a lot of case law that is out there related to the interpretation of insurance policies. So I would pick the one that is most likely to get a favorable response. And then what you do is you then take that decision and you bring it to the other courts and say, look, this judge, you got to be consistent with this judge, and it just puts pressures on the judge. Generally, there's in New York 6 years to bring a lawsuit, not to make the claim, but to bring the lawsuit. So as long as you make that claim in a timely fashion, you're preserving your ability to bring the lawsuit. Now, sometimes the insurance policy accelerates the time frame to bring the lawsuit, but the outside would be 6 years.
Okay, got another question that came in here. If you already filed a claim and it was denied, but you hadn't included the broad language for the claim that you alluded to before, would this be a reason to amend the claim?
without seeing the language of the claim, my answer would broadly be yes, but it kind of depends on what their denial is. So if they denied based on, if you said, I'm making a claim based on civil authority, and their denial was, no, you have no coverage for civil authority, and you have no coverage for for virus or bacteria, then you don't have to then make a claim for virus and bacteria. If you have a virus and bacteria endorsement, meaning you have insurance for it, but then they try to exclude it for some reason, and you did not make that claim, and they did not issue a denial with respect to it, yes, you should make a amended claim. You just want to make sure that everything is incorporated in your claim. I hope that was clear. If it wasn't, just text Mark and let me know how I can make that, what wasn't clear about that.
Just one more question just came in. After they get the denial, what's the next step? Go right to an attorney?
Yeah. I mean, after you get the denial, it's called the issues joined. They denied it, and either you can try to negotiate with them, but they haven't resolved any of these, and I think they don't want the dam to break as a industry, so they are holding fast, and they're not looking to resolve any of these cases as of yet. I think once they start, it's going to be hard for them to each individual insurance company, based on their position, to deny other policyholders. So if you want to take action, yeah, you need to get to an attorney who will then, there are lots of options as to whether it'll all be based on the strength of your individual policy and the strength of the denial as to what the next course of action is. One course of action may be sit tight and wait, and let's see how, because you don't have the strongest language. But if there's a break in the dam and they start resolving these, there's arguments to resolve it, versus you have very good coverage and there is no adequate denial of coverage and the disclaimer is, then I would say you should start that lawsuit. But it's very fact specific based on your particular policy.
All right, that's all the questions that came in, unless Walter has some other questions.
Yes, I have two more. So we have many commercial landlords as clients, and some that are on this webinar, and they've asked if it's common for landlords to have business interruption insurance in their policies, and what your thoughts are on that.
Yeah, it's common. So the business interruption policies fall generally under the general liability coverage that you buy. So all property owners and landlords have general liability coverage, and you would have a separate endorsement in that policy package for business interruption. And my answer is generally it's there. So that endorsement is often found in commercial real estate properties. But you just have to look at your policy. It's really what and it's not, that part of it isn't hard to find. It'll have a separate endorsement. You can just flip through it. I've seen some that are 450 pages. I've seen some that are 100 pages. You just flip through it and you'll see something that says business interruption coverage, or you'll see something that says civil authority coverage, right? The underlying language within that policy, I would not, you'll read it, but you may not understand the nuances of the language, but at least you know there's what's called an endorsement. You do have that coverage, and then it's a fight as to whether or not it's excluded based on what's happened.
Okay, and also we have some clients that have been closed down as a restaurant, but they're doing the takeout and delivery like you spoke about before, and they don't know if they would be covered for a reduction in revenue due to the closure of the area where people would be dining.
Yeah, so it's called business interruption. It's not called business cessation or permanent closure. And whether or not you're entitled to it, it all depends on, do you have coverage and what's the extent of that coverage? If you're found to have business interruption coverage, that coverage will include, I haven't seen one where it doesn't include loss of revenue. Now, it doesn't have to be total loss of revenue. It doesn't say that in the policy. If it says that in the policy and you have to have total loss of revenue, then you don't have coverage, but I haven't seen that. It's business interruption that results in loss revenue. So it doesn't require total.
Thank you. Mark, did another question come up just now? I don't.
Just
Oh,
what type of claim should be made?
I mean,
It's a general business interruption.
Yeah, well, I mean, the type of claim that should be made is, I have an insurance policy with you that I believe covers me for business interruption and bacterial exposure. As a result, business interruption and civil authority. Okay, I misspoke there. Business interruption and civil authority. Due to the governmental response during this pandemic, as well as the losses that I've sustained, I am making a claim for any and all benefits that my policy affords me. As broad as that. You don't have to define exactly what they are. You have to say, I want everything that I'm entitled to. Because there's a presumption in New York, actually everywhere, that there's a presumption that the parties act in good faith. That just doesn't match with reality oftentimes, but the presumption of good faith is that you have put them on notice that they wrote the policy, they gave the endorsements, they're the insurance company, they are supposed to act in good faith and provide to you everything you're entitled to. That's what you're asking for, everything that my policy allows me to. Now, if they say, no, you're not entitled to anything, that's where the fight is.
Okay, let's
Mark.
questions that came in.
Okay, so what I'd like to touch upon is if you now, after listening to this webinar, decide to file a claim and you get denied and you'd like to retain Andrew's firm, or you want to use your own attorney, but Andrew specializes in this, as he said, you would need to provide your policy and your denial letter. And then I guess, Andrew, just explain what, after you review it, you would probably have an idea of what you have a claim or not.
So what you can do is just email me, and I'm happy to, my email address is A Finkelstein, AFINKELS, like Sam, ELSTEIN, A Finkelstein @jmlawyer.com. Just email me your policy and your denial letter. I have a team of lawyers who are taking that and they're breaking it down to see where we can have coverage or not. I'll confirm that I got it. Takes a little while because we have a lot of policies coming in, but we do a whole strategy on every single policy that comes in, and we'll let you know, either you have a really good shot, we'll call it A, B, or C. We should start right away. Let's see what else happens, or sit tight, depending on how the water breaks. Maybe at the end of this, we can get you coverage. That's just the reality of it. And we'll outline the reason why.
Andrew, but before we look to conclude anything, another question came in. It said, what does your gut tell you about the success of filing for this claim?
So that's an interesting question. Here's what my gut tells me. As in everything else, there are going to be some winners and there are going to be some losers. There's no way that all policyholders are getting nothing, and there's no way that all policyholders are getting something, right? I hate it. I know that's a broad answer, but I will tell you that there are definite policies where people are getting all of their coverage. And there are definite policies where they wrote them really well and the exclusions are really clear and there's no inconsistencies and we can't get around it. But always remember that these policies most of them were not written with the thought of a pandemic. So what they're trying to do is exclude all of the harms caused by a pandemic when they didn't write that into their policy. So they are going to have to jump through some hoops to get there. Now, it all depends on the interpretation of those clauses. But that's why when Walter said earlier, well, we know that in the next round of policies that are written, they are going to include pandemics and everything that people are experiencing. Well, I welcome that. Why? Because then we just say to the judge, they had the ability to exclude it. Because they're doing it now. And they didn't exclude it when this policy was written. So why should they get the benefit of what they're writing in the exclusion in 2 months or 3 months from now when they didn't write it in here? The presumption is coverage. So those are just real broad arguments, but they definitely carry weight. But it's all, again, specific to the policy that's in place, the language.
All right, perfect. Thank you.
All right.
Okay.
And if anybody has any further questions, they could always email or call the office. And if you didn't get Andrew's email, we could always, make the introduction as well, if get to write it down. So Andrew, thank you for your time.
My pleasure.
And thank you. And everybody on the webinar, thank you. And give us a call if you have any questions. Okay. Everybody stay safe and thank you again. Bye-bye.